All right, let's now proceed with our discussion on RA 9165, and we are now on section 15. Can you hear me? Can you click like if you can hear me clearly? Okay, thank you guys. So section 15, can I request Cirex? Uh, what was that? Si Cirex. Okay, can you please read this provision, section 15? Kutob sa apply.
Section 15 provides that a person apprehended or arrested who is found to be positive for use of any dangerous drug after a confirmatory test shall be imposed a penalty of a minimum of 6 months rehabilitation in a government center for the first offense, subject to the provisions of Article 8 of this Act. If apprehended using any dangerous drug for the second time, he shall suffer the penalty of imprisonment ranging from 6 years and 1 day to 12 years, and a fine ranging from 50,000 to 200,000, provided that this section shall not be applicable where the person tested is also found to have in his possession such quantity of any dangerous drug provided for under Section 11 of this Act, in which case the provisions stated therein shall apply.
Okay, thank you, C-Rex. So this is very clear ha na a person who tested positive should not possess any quantity of drugs in order to fall within the provision of section 15, okay? So dapat ang madakop diri is only for the use of dangerous drugs, all right? He should not in his possession or he should not in any way possess quantity of drugs, any quantity of drugs in order to fall within Section 15. So if in addition to positive use, masakpan siya nga naapod siya gida nga drugs no of any quantity, he will be liable. That person will be liable under Section 11 and not under Section 15 since there is a no cut-off quantity between Sections 11 and 15 and because of the phrase less than in Section 11, which is any quantity less than 5 grams and 300 grams only. Okay? So as an example, in the case of People versus Del Monte, ninyo ng Supreme Court, for instance, the sale of shabu is penalized under Section 5, Article 2, where the sale of any dangerous drug, regardless of its quantity and purity, is punishable by life imprisonment to death and a fine of 500,000 pesos to 10 million pesos. The trial court pegged the fine at 5 million, which the Court of Appeals reduced to 500,000. So both amounts are within the range provided for by the law, but the amount imposed by the Court of Appeals considering the quantity, okay, of the drugs involved as more appropriate according to the Supreme Court. So again, in order for Section 15 to find application, the the person apprehended should not possess any quantity of drugs. Otherwise, dili ang Section 15 imong gamiton but Section 11. Okay? Let's now proceed to confirmatory tests for conviction under Section 15. Okay, in the case of People versus Lopez, the Supreme Court said that Section 38 requires a confirmatory test of the result of the urine sample of the accused for conviction under Section 15. So considering that the chemistry report merely contains now the results of the screening test conducted, the same cannot be valid before any court of law absent the required confirmatory test report. So without the requisite confirmatory test, in this case, according to the Supreme Court, Lopez cannot be held criminally liable for illegal use of dangerous drugs under Section 15. So timan na in order to have a conviction or in order to reach a conviction under Section 15, duha ka test ang imong isubmit sa court. Una is the screening test mo na ang primerong buhaton, and of course, second is the confirmatory test under Section 38. Okay? Timan ina ninyo. Kung mahimo na mo pohon mga police officers and you would be assigned in battling the war on drugs, or B, among the officers um, uh, enforcing the provisions of RA 9165. So timan ilang ninyo ang mga requirements in order for you to reach a conviction. Okay, so in this case also, the Supreme Court defined what is confirmatory test, and it stated, it highlighted the definition provided for in RA 9165, which states that a confirmatory test is an analytical test using a device, a tool or equipment with a different chemical or physical principle that is more specific, which will validate and confirm the result of the screening test. It is the second or further analytical procedure to more accurately determine the presence of dangerous drugs in the specimen. Okay, so that is confirmatory test. Now, in interpreting RA 9165, there are some presumptions under this particular law. Okay, so according to the Supreme Court, the possession of equipment, instrument, apparatus, and other paraphernalia or dangerous drugs fit or intended for smoking, consuming, administering, injecting, ingesting, or introducing any dangerous drug into the body shall be prima facie evidence that ang possessor nga nadakpan has smoked, consumed, administered to himself, injected, ingested, or used a dangerous drugs, and therefore has violated Section 15 of RA 9165. So kung madakpan ka and in your possession um, there will be an equipment, instrument, or apparatus or other paraphernalia nga gamiton for the dangerous drugs no in consuming, administering, or injecting, or ingesting or introducing dangerous drugs into the body, ang presumption ana is that ikaw ang mugamit ana para sa imong kaugalingon, and therefore you have violated section 15 of RA 9165. Okay, so mo na presumption under the law. Of course, because this is a presumption, it also follows that this is rebuttable. Okay, presumption naman na siya, it's not conclusive. So you can always contradict or interpose a defense that indeed it is not really yours. Okay, but that's the presumption that can be rebutted during trial or presentation of evidence for the accused or defendant, as the case may be. Okay. Let's now proceed to the concept of plea bargaining under RA 9165. Okay. Before this case, RA 9165 altogether prohibited or disallowed the concept of plea bargaining among the accused. Okay. But in the case of Estepona versus Lobrigo, no, plea bargaining in cases involving dangerous drugs was already allowed by the Supreme Court. And it declared that the provision in RA 9165 expressly disallowing plea bargaining in drugs cases, particularly Section 23 of Article 1, is unconstitutional for contravening the rule-making authority of the Supreme Court. Kaya ingon ng Supreme Court, kami raman ang may authority to create rules with respect to application of laws. Okay, so following this, or I mean, yun ang Supreme Court, kami raman ang naay rule-making authority when it comes to the provision on plea bargaining because this is within our power. Okay, so following this pronouncement, the Supreme Court issued Administrative Number 18-03-16-SC providing for a plea bargaining framework in drugs cases, which was required to be adopted by all trial courts handling drugs cases. So atong tagsa-tagsaon ang guidelines laid down in AM number 1803-16-SC. Okay? So here the court explained which violations of RA 9165 are eligible for plea bargaining. So gi-classify sa Supreme Court na ay mga kaso nga di gyud ka pwedeng mo plea bargain, but there are also cases according to the Supreme Court nga allowed ang plea bargaining. And the court stated that plea bargaining is generally not allowed for the sale or trading of dangerous drugs except for small amounts of shabu or methamphetamine hydrochloride and marijuana. Okay? So for shabu, gibutangan nag-weight. Okay? For shabu, if the amount is less than 1 gram, meaning 0.01 to 0.99 grams, the offense is considered minor enough to allow plea bargaining. And it can be treated as if it were a possession of drug paraphernalia offense under Section 12 of RA 9165. O sige, pasabot anong plea bargaining, attorney? In the concept of your criminal procedure, in your criminal procedure, no, you would learn that there is what we call arraignment, di ba? During the arraignment, basahan ka ana sa imuhang giakusar sa imuha as found in the information. Okay? In the information, gipasangin ka nga ni committer sa usa ka crime. And then if you would plead guilty to a lesser offense, that's what we call plea bargaining. Okay? Moingon ka nga, sige ako na lang nang angkonon pero to a lesser offense. Okay? So suppose in this case, no, in this case, you are charged with a violation of RA 9165, particularly possessing, let's say, 0.95 grams of shabu. Okay? 0.95 grams of shabu. Question, can you or will you be allowed to plea bargain to a mere possession of drug paraphernalia? Pwede ba ka nga, dili lang possession of dangerous drugs in the amount of 0.95 ako ang i-plead guilty, Your Honor. I will only plead guilty to possession of drug paraphernalia. Let's say tuter. Kana lang akong i-plead guilty, Your Honor. Pwede na. Can you do that under the Administrative Matter number 180316 of the Supreme Court, issued by the Supreme Court? Unsa ning naa sa number 2, for shabu daw, if the amount is less than 1 gram or 0.01 to 0.99 grams, the offense is considered minor enough to allow plea bargaining, and it can be treated as if it were a possession of a drug paraphernalia offense under Section 12 of RA 9165. Meaning, pwede kang mo plea bargain to a lesser offense, and the lesser offense is that provided for in Section 12 RA 9165. Okay? This is very important for you, no? Kag when you become police officers puhon, you have to be very careful when you make allegations in your complaint. And as much as possible, um, ayaw lag sunod sa mga ubang pulis nga punaan ang gibugaton sa droga nga ilahang nasikop. Worst, kana bitaw mo planted gyud og mga shabu sa mga tao nga who did not really possess shabu, but for purposes of kaning gitawag nilang quota, they would do it para maka-reach sa quota. Ha? So remember sa to, plea bargaining, generally it's not allowed for the sale or trading of dangerous drugs except small amounts. And what is the weight of the small amount nga pwede nimo nga ma-plea bargain? Pila kung shabu? Pila ka grams para pwede kang maka-plea bargain to a lesser offense of possession? Pila?
Less than 1 gram,
One
ma'am.
gram.
Hmm. Less
0.01
than?
to
Less than?
0.99 gram.
Yes. Okay, very good. So for marijuana, lahi man ang shabog marijuana. Ang marijuana is dried naman nga leaves, di ba? So for the marijuana, the same principle applies. If the amount sold is less than 10 grams, 10 grams lang si marijuana, okay? So that is 0.01 to 9.99 grams. It can also qualify for plea bargaining. However, if the amount exceeds 1 gram for shabu and 10 grams for marijuana, plea bargaining is disallowed because the quantity is considered significant. Okay? So in this resolution issued by the Supreme Court in April 2, 2019, no, it emphasized this approach based on the need to address the overwhelming number of cases involving shabu and marijuana. And it also considered the input from the judges and the Philippine Judges Association that such small amounts do not warrant the harshest penalties and can fit within lighter offenses. And this policy also reflects the Supreme Court's aim to manage minor drug offenses, okay, or minor drug cases more efficiently while reserving stricter penalties for the offenders with larger quantities of drugs. Okay? So, timan-ina ninyo nga mga guidelines. Now let's proceed to entrapment, instigation, buy bust, and frame up. Okay. When we talk about entrapment, you have already came across the concept of entrapment in your criminal law 1, diba? When we talk about entrapment, this is a legitimate police operation where the officers catch a criminal in the act of committing a crime. And the idea to commit the crime comes from the criminal, and the police only provided an opportunity to catch the suspect. Okay? Example, in a buy-bust operation, an undercover officer poses as a buyer to catch someone selling illegal drugs. The outcome would be the entrapment here is allowed under the law and the accused can still be prosecuted and convicted. Kay bauman mus concept sa buy-bust operation, no? Kanabitang the police officer would pretend to be a buyer and he would be called pusher buyer. Ingon siya nga mopalit siya og druga. Kaya ila pa man surveillance and they would know nga kana siya mo na maligya mga drugs. They would conduct a surveillance and then they would deploy someone to act as a buyer. Once katotong gisgutan before, once mo bayad na siya, unya ihatag na niya or once ihatag na niya ang druga, the buy-bust operation is already consummated and in this case, entrapment is already allowed and the accused can be prosecuted now and hopefully later on be convicted for violation of RA 9165. Entrapment is different from instigation. Kaya ang instigation, ang criminal idea na nagikan sa police or the agent. And siya ang mo encourage sa akusado to commit the crime. Mao na ang instigation, okay? So the criminal idea comes from the police or their agent who encourages the person to commit the crime. Here, the officer is actively involved and acts as a co-principal in the crime. And the outcome is that kung instigation ang imong gibuhat, kana bang nagpa-pretend siya nga siya ang poster buyer, ang pulis, nya ingno niya, oh, ibaligya niyo kay para tagaan ti ka og unsa na kanini ang ginansya. Okay, or tagaan ti kag 5,000 ibaligya ni. Ngana. So in this case, this is instigation because the criminal idea comes from the police, okay? And he encourages the person or the accused in this case to commit the crime, okay? So ang tawag ana dili entrapment because ang entrapment criminal na daan ang tao nga nibuhat sa crime, di ba? Nya ila lang gustong masakpan, munang mukandak sila og entrapment operations or for cases of drugs kanang gitawag by bust operations, okay? So in instigation, ang instigation, this is not allowed, okay? And the accused will be acquitted because they would not have committed the crime without being induced by the authorities involved. Kakuha mo? Kakuha mo sa diferensya sa entrapment o instigation? So, unsa may allowed? Entrapment or instigation? Unsa may allowed under the law? Is it entrapment or instigation?
Entrapment, ma'am.
Entrapment, ma'am.
Entrapment.
Okay. So, unsay diferensya sa entrapment and instigation? When we talk about entrapment, the suspect already intended to commit the crime and the police only caught them in the act. In instigation, it is the police that caused the person to commit the crime, which wouldn't have happened otherwise. Okay? Lahi po siya sa frame up. Kay bao naman mo aning concept sa frame up. Okay? Frame up occurs when someone is falsely accused of a crime they did not commit, usually involving fabricated evidence or manipulated circumstance to make it appear that the accused committed offense. B, in the recent turn of events, no, naamoy na hinumduman or naamoy nakita nga sakto gini nga example sa frame up ay pwede gini na kung mahatag ni ma'am nga example. Naamoy nakita nga example nga frame up situation involving, let's say, big personalities nga na-frame up.
Ma'am, ang kuan ma'am, ang planted ma'am, pwede na makuan siya ma'am sa frame up ma'am.
Pwede na. Pwede na. Kana, fabricated evidence or manipulated circumstance, kanang plantera nimo, that's considered frame up. Also, thank you for that example, Brian. There's also one instance no nasikat gid kaayo ron. I don't know if you've been following no the hearings in the Senate and the Congress. Si Senator Leila de Lima, you know her? Do you know her?
Yes, ma'am.
Yes, ma'am. Yes, ma'am. Ni
She's
pala
been-
rato kaso ma'am.
Oh, she's been framed up by the recent administration to make it appear that she was a protector of the drug lords in the Bilibid. And as a result, she was prosecuted for the violation of RA 9165, and also she was also prosecuted for katong anti-graft and corrupt practices nga violation. But these cases have been dropped. She was acquitted, and some of the cases were also dismissed because of the insufficiency of evidence on the part of the prosecution. This is a classic example of frame up, because if you can still recall, I think bata pa mo atong time ano, napasing mo sa high school, or I think you were still in your early high school when Leila de Lima was actually tried publicly by the galamais of the administration. She was implicated as having the protector of the drug lords in the Bilibid, to the effect that there were persons deprived of liberty who testified against her na ato kuno nas legal lila dilima sa Bilibid, mag-party-party daw na dito niya, magdadaw na siyang sako-sako nga bag, sako-sako nga kwarta na ang iyang driver daw is nakasabwat and all that. So based on those stories, si Leila de Lima was condemned by the public, and she was incarcerated for a long time. I think it took 6 years for her to be freed from the incarceration, no, caused by the frame up orchestrated by the previous administration. So that's a classic example of frame up. You will be falsely accused of a crime that you did not commit. Okay? Based on fabricated evidence. One example also, katong giingon ni Brian, I think it was Brian who said that, kanang magplanted ka. Nagkon na ka, unsa na inyong tanaw ka na ining kagabi gani, sana checkpoint. Nag-checkpoint ra, but because there's a quota, no, what you would do is that hulga ni mo nun, o shabu, magamay pakita shabu, or plantira ni mo whatever that you can open, or bisag kung naalang gani gamay violation sa traffic, apila ni mo og violation sa RA 9165. That's an example of frame up. And that is not allowed. That is illegal. And if you would be caught doing that, you can be prosecuted. Okay? You can be prosecuted criminally, and you can also be held liable administratively. Okay? So that's frame up. So what are the three concepts that we have just discussed? No, sa to entrapment, sa to ikaduha,
Instigation.
Instigation.
institution, and this one frame up. Okay? Among the three terms, the entrapment, instigation, and frame up, unsa man ani ang legal ra and allowed by the law?
Entrapment, ma'am.
Entrapment. It's the only entrapment. Okay? Sige. So let's read the brief history of entrapment cited by the Supreme Court in the People versus Doria. Si Rex, can you please read this?
Okay, ma'am. Thank you, ma'am. Brief history of entrapment. People v. Doria, GR. Di na basahin, ma'am. Entrapment was unknown in common law. It is judicially created 20th century American doctrine that evolved from the increasing use of informers and undercover agents in the detection of crimes, particularly liquor and narcotics offenses. Entrapment sprouted from the doctrine of estoppel and the public interest in the formulation and application of decent standards in the enforcement of criminal law. It has also took off from a spontaneous moral revulsion against using the powers of the government to beguile innocent but ductile persons into lapses that they might otherwise resist. In the American jurisdiction, the term entrapment has a generally negative meaning because it is understood as the inducement of one to commit a crime, not contemplated by him, for the mere purpose of instituting a criminal prosecution against him. The classic definition of entrapment is that articulated by Justice Roberts in Sorrells v. United States, the first Supreme Court decision to acknowledge the concept Entrapment is the conception. That's all, ma'am.
Please continue.
Okay, ma'am. And planning of an offense by an officer and his procurement of its commission by one who would not perpetrated it excepted for the trickery, persuasion, or fraud of the officer. It consists of two elements: acts of persuasion, trickery, or fraud carried out by the law enforcement officers or the agents to induce a defendant to commit a crime, and B, the origin of the criminal design in the minds of the government officials rather than that of the innocent defendant, such that a crime is the product of the creative activity of the law enforcement officer. Entrapment is recognized as a valid defense that can be raised by an accused and partakes of the nature of a confession and avoidance. It is positive defense. Initially, an accused has the burden of providing sufficient evidence that the government induced him to commit the offense. Once established, the burden shifts to the government to show otherwise. When entrapment is raised as a defense, American federal courts and a majority of state courts use the subjective or origin of intent test laid down in Sorrells to determine whether entrapment actually occurred. The focus of the inquiry is on the accused predisposition to commit the offense charged, his state of mind and inclination before his initial exposure to government agents, all relevant facts such as his mental and character traits, his past offenses, activities, his eagerness in committing the crime, his reputation, etc., are considered to assess his state of mind before the crime. The predisposition test emphasizes the accused propensity to commit the offense rather than the officer's misconduct and reflects an attempt to draw a line between a trap for the unwary innocent and a trap for the unwary criminal. If the accused was found to have been ready and willing to commit the offense at any favorable opportunity, the entrapment defense will fall even if a police agent used unduly persuasive inducement.
Yes, ma'am.
Okay. Okay, ako na lang tiwa. Sige, kay murag kang Rex ng freeze, okay? So, some states adopted the objective test first authoritatively laid down in Grossman versus State, rendered by the Supreme Court of Alaska. Several other states subsequently adopted the test by judicial pronouncement or legislation. Here, the court considers the nature of the police activity involved and the propriety of the police conduct. The inquiry is focused on the inducements used by the government agents, on the police conduct, not on the accused and his predisposition to commit the crime. For the goal of the defense is to deter unlawful police conduct. So the test of entrapment is whether the conduct of the law enforcement agent was likely to induce a normally law-abiding person other than one who is ready and willing to commit the offense. So for purposes of this test, it is presumed that a law-abiding person would normally resist the temptation to commit a crime that is presented by the simple opportunity to act unlawfully. Official conduct that merely offers such an opportunity is permissible, but overbearing conduct such as badgering, cajoling, or importuning, or appeals to sentiments such as pity, sympathy, friendship, or pleas of desperate illness are not. Okay, it was also in the same case of People versus Luo Chu and Oi Su Ting that the Supreme Court first laid down the distinction between entrapment and instigation. It said that the appellate court declared that there is a wide difference between entrapment and instigation. The instigator practically induces the would-be accused with the commission of the offense himself, and himself becomes a co-principal. In entrapment, ways and means are resorted to by the peace officer for the purpose of trapping and capturing the lawbreaker in the execution of his criminal plan. So in People versus Tanchong, it declared wait lang ha, is no bar is no bar to the prosecution and conviction of the lawbreaker. And that pronouncement in People versus Galicia was affirmed in People versus Tua. Entrapment was held not to be contrary to public policy, and it is instigation that is deemed contrary to public policy and therefore illegal. Okay? So I think we have already discussed that earlier, and it's also good to also know the brief history of entrapment in the American within the context of the American jurisdiction. Okay? So now let's look at this concept also, the mala prohibita and mala ense doctrine, no, in relation to entrapment and instigation. So you already have an idea of the concept of mala prohibita and mala inse. When we talk about mala prohibita, these are crimes not inherently evil or immoral, but are prohibited by law to maintain order in society. Examples of mala prohibita or crimes that are considered mala prohibita are drug offenses or illegal gambling. And breaking these laws would result in criminal liability regardless of the intent. Intent here is never an issue, okay? In Malaense, no, example, anak ka ng mga crimes of murder, theft, or arson, and these are inherently wrong or immorals. An intent may be considered in the presentation of evidence on the part of the prosecution and the defense. Okay, for entrapment and instigation in drug operations, we've discussed also that in bypass operations, entrapment is frequently used to catch offenders in drugs cases, and the court differentiated between the entrapment and instigation. Sa entrapment, di ba, ang law enforcers catch a person who is already planning to commit a crime. In instigation, ang officers induce or encourage someone to commit a crime that they wouldn't have committed had it not been for the instigation of the police officer. Okay? Why is it important to know this? Because anti-drug laws are regulatory laws aimed at curbing illegal drug activities to protect society. And violating these laws create mala prohibita offenses. Therefore, even without moral intent, offenders are liable if the law is broken. In People versus Doria, the court emphasizes that anti-drug operations require strict legal procedures, and instigation is not allowed as it makes law enforcers accomplices rather than protectors of the law. So this distinction ensures that while entrapment helps fight drug crimes, it must not cross into instigation, which could result in wrongful convictions. Okay? Okay, so is it necessary that we hear the testimony and we know the identity of the informants in drugs cases? The Supreme Court in drug-related cases, informants or the informant's testimony is not required for a conviction. The informant's role is mainly to support the testimony of the posture buyer or the arresting officers, making it non-essential. Okay? The courts rely heavily on the credibility and reliability of the arresting officer's accounts, even if there's only one trustworthy witness. Okay? Also, it is up for the prosecution to decide which witnesses to present based on their relevance to the case. So, a single reliable witness can suffice for conviction as long as the testimony is clear and trustworthy, no matter how many witnesses or no matter how many witnesses testify on the case. Informants are not usually called to testify because, di ba, confidential gani na sila. Di gani na to ipahibaw nga muna sila nagtugaan nga ni violate dahil ang usa ka tawo og RA 9165. The reason being, preserving their cover is essential to allow them to continue working with the authorities. Also, their lives may be put in danger if dealers learn their identity, as these criminals often retaliate against informants. Also, the police prefer to keep informants anonymous to maintain their usefulness in future operations. When will these informants be necessary? The informant's testimony might become necessary in situations where the accused denies involvement in drugs cases, and when there are significant inconsistencies in the testimony of the arresting officer, and when the informant was the only witness to the transaction. So diha ra na ang mga instances nga necessary si informant mo testify sa korte. Okay? Um, In the case of People versus Dulay, the court emphasized that the informant's testimony are only corroborative and not crucial for securing a conviction. The Hu Chua and Nicholas cases also highlighted the importance of maintaining the confidentiality of informants to protect their safety and preserve their ability to assist in future operations. Okay? Also note, guys, that in cases involving illegal sale or possession of dangerous drugs under Section 5 RA 9165, the prosecution must prove not only the elements of the crime but also the corpus delicti, which refers to the substance of the crime itself. Okay? Unsa ng corpus delicti? Sige tagkabatian ano? When we talk about corpus delicti, this means the body or substance of the crime. In the context of drugs cases, this refers the illegal drugs involved. Okay, so the dangerous drug itself, it could be shabu or marijuana, as the case may be, is considered to be the corpus delicti. Okay, so there are elements that you need to prove. No, the prosecution must show that the crime of illegal sale or possession of drug occurred, and then the drugs were handled properly from the time of seizure until the presentation in court. Okay, kailangan sad ibutang or i-present that there was a chain of custody. Okay, there was a proper chain of custody. Is it important to prove that the corpus delicti, or why is it important to prove the chain of custody? It is important because to prove corpus delicti, the authenticity of the drugs must be beyond question. Okay? If there are gaps in the chain of custody or if the drugs are missing, it raises doubts that the evidence is fabricated and it would weaken the prosecution's case. Okay? So, importante kaayo nga maprobar nimo nga walay gap sa chain of custody. Okay? From the moment nakuha nimo ang drugs up to the time nga gipresentar ang arresting officer sa court, no, for presentation sa ebidensya sa prosecution, kailangan maprobar ang proper chain of custody. Dapat wala naguba ang chain of custody. Okay? And it is the prosecution's responsibility to demonstrate that the drugs presented as evidence are the same ones that were seized from the accused. If the chain of custody is broken, it could lead to acquittal due to the lack of proof of corpus delicti. Okay? Because you can easily change the corpus delicti if you cannot prove the proper chain of custody. Diba? So, muna importante kaayo that you have to really prove that the drugs were handled properly from the time of the seizure up until the time of their presentation in court. Okay? So proving corpus delicti is as crucial as proving the elements of the crime of drugs itself. Okay? So chain of custody. Okay. So let's now proceed to our last topic for this afternoon. No? When we talk about chain of custody, this refers to the unbroken trail of evidence showing how the seized drugs were handled from the moment they were confiscated to their presentation in court. So this will ensure butong ganiha that the same drugs taken from the suspect are the ones presented during trial. Okay? So why is it important? Again, we said it is important because uh, this will prove that there was no gaps in the chain of custody. And in your RA 9165, particularly Section 21, it provides there The specific rules on how seized drugs should be documented, stored, and presented to preserve their integrity. The purpose is to prevent tampering or planting of evidence which could compromise the case. Okay? Some courts struggle to decide when strict compliance with the procedure is necessary and when exceptions can be made. But still, the courts would always take into consideration the proper chain of custody. Uh, Also, the prosecution must prove that the drugs presented in court are exactly the same ones seized from the accused, and it should be demonstrated that the evidence was not altered. So, unsa may mahitabo if ang chain of custody is broken? If there are gaps in the chain of custody or doubts about the authenticity of the drugs, the prosecution's case would fail because the corpus delicti or the body of the crime has not been properly established. Okay, so in conclusion, maintaining a strict chain of custody ensures fairness in drug-related cases by preventing the introduction of tainted evidence and of course upholding the integrity of the legal proceedings. Okay? So I think those are some of the concepts or some of the important concepts in RA 9165.